Our next session is entitled Reclaiming Human Rights and the Rule of Law. Not an easy task, so it's important to have some heavy hitters in the battle, and we have them up on stage with us today. That's Professor Anne Orford and Greg Barnes. And I'd like to invite Anne Orford to speak first. Anne is Professor of International Law at Melbourne Law School and Visiting Professor of Law at Harvard and Stockholm University. Her focus is international law, international dispute settlement, international economic law, geopolitics and climate change. Her latest book, International Law and the Politics of History, was awarded the 2022 European Society of International Law Monograph Prize. Her address is titled Espionage, Extradition and Empire. Anne Orford.
Well, many thanks for that introduction. I'd like to begin by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the land on which we're meeting, and pay my respects to their elders past and present. I'm really delighted to have been invited to take part in this conference. I accepted immediately, both because of the unacceptable situation in which Julian Assange finds himself, and also because as an international lawyer, I'm concerned by the dangerous precedent set by his treatment over the past decade. So this panel's been invited to focus on the broader aspects of the case in terms of the precedents it raises in relation to human rights and the rule of law. We often think about human rights and the rule of law as necessarily aligned, but law is a human construction. It's a practice of argument. It's shaped by the choices, decisions, and judgments of the many human actors involved in its routine operation. And so here I want to focus on the cumulative choices that have been made by different prosecutors, courts, and ministers across the past decade. Like Michael West in an earlier session, when I began to think about the paper, there were many, in his words, data points that I could have drawn upon to think about these issues. But like him, I realised that I really wanted to say something broader about institutional or systemic failures that emerge when you add all the choices up together. So each of the choices I'm going to sketch here, there were many to choose from, I've chosen 7, have pushed the law in the direction of protecting US power and limiting the rights of Julian Assange. And when we add each one of those exceptional choices together, the effect is to create a form of law that I think can best be described as imperial. So most of us in the world don't get to participate in shaping this law. The resulting law may respect the human rights of at least some US citizens, but it systematically erodes the rights of imperial subjects, that is, most of us. So before I sketch just some of the decisions and choices that have been made within the Swedish, the US and the UK legal systems, it's worth remembering, of course, that this legal story begins with the leak of materials that put on the public record information relating to alleged state crimes and to state corruption, and we've heard much about that already today. The publications, of course, included the Iraq war logs, the Afghanistan diaries, Guantanamo Bay detainee files, and US diplomatic cables, and provided material that's been relied upon by journalists, lawyers, and human rights activists as evidence of war crimes, torture, pressure placed upon governments, and conspiracy to cover up civilian deaths. So the first choice I want to look at involves Sweden. As you'll remember, in May 2012, Sweden issued a European arrest warrant in relation to the preliminary investigation of sexual assault allegations that had been made against Julian Assange. He was wanted for questioning but had not been charged. This was a preliminary investigation. And once he was questioned, it was possible that he would either be charged or the charges dropped, which they eventually were. So this really looms very large, I have to say, when I talk to lawyers about this case. For many people, this is really where they pause and sometimes stop. But Julian Assange then sought asylum in the Ecuadorian embassy in London after the decision of the Supreme Court to permit extradition to Sweden under that warrant. And that was not because he wanted to skip bail or avoid facing those charges, although it's disturbingly often remembered in those terms, but because he and his legal advisors were concerned about a loophole in the US-Sweden extradition treaty permitting the US to borrow a suspect from Sweden for the purposes of criminal prosecution without full extradition proceedings. I'll come back to the law on extradition in a moment. But Assange, his lawyers, and the Ecuadorian government all accepted that it was necessary for the allegations in Sweden to be taken seriously, but that was also important for the rights of Julian Assange not to be extradited to the US to be taken seriously. And that was because Assange had a compelling right to seek asylum in order not to be subjected to political persecution or torture in a US prison system that numerous human rights rapporteurs, NGOs and others have consistently described as amounting to cruel, inhuman and degrading treatment and, in some cases, to torture. Both sets of rights needed to be respected. But the UK and Sweden chose not to discuss any agreement that could safeguard both the rights of the Swedish complainants and Assange's rights not to be imprisoned for journalism. And a leading Swedish international lawyer, Uwe Bring, at the time said to Radio Sweden that it would have been possible for the prosecutors to go to London directly. But now it had become a matter of prestige, and the US and the Swedish legal system couldn't back down. So choice number one. So let's turn to the United States. Many, many choices we could look at here. I'll just look at three. The first is the decision to prosecute a publisher under the Espionage Act. And we've already heard about that this morning. The US has requested the extradition of Julian Assange on 17 charges under the Espionage Act and one under the Computer Fraud and Abuse Act. Collectively, if he was found guilty of all the charges, potentially adding up to 175 years in prison. The US Espionage Act is an omnibus act. It involves really quite a few laws. They're widely said to be extremely opaque, confusing, and poorly drafted by US lawyers. We usually understand espionage to mean something like spying for a foreign government or maybe selling things to a foreign government, and it does cover that, but it also covers much more broadly the gathering, transfer or disclosure of secret information without authorization. And more information is kept secret by the US government. Since the 2010s, it's estimated that between 50 and 90 million documents have been classified every year. So the power of the Espionage Act lies in the work it does to protect those secrets. It's not necessary to prove a charge of espionage that there be a harm to national security, and it's no defence that the leaking was in the public interest. In recent years, the US government has begun to bring espionage charges against people for disclosing information to the media, but the case of Julian Assange is the first time that an espionage charge has proceeded against the publisher of information that was leaked to them. And initially, the Obama administration chose not to prosecute Julian Assange because of what they referred to as the New York Times problem. What is the difference between what Julian Assange did in terms of publishing leaked information and what the New York Times does? The charges against Julian Assange focus almost entirely on his role in obtaining and publishing classified materials, things that journalists regularly do. And many journalists, including in the past few weeks, many human rights NGOs, many lawyers, many free speech organisations have expressed concern about this aspect of the prosecution. As James Goodall, the former Vice President and General Counsel for the New York Times during the Pentagon Papers trial, now an adjunct professor at Fordham School of Law, has said, if the US succeeds in prosecuting Assange under the Espionage Act for publishing information about its war crimes, it will be shredding the First Amendment's press freedom guarantees. But the damage will extend far beyond US borders. Assange is not an American, and WikiLeaks is not based in the United States. The United States is asserting the right to track down any journalist anywhere in the world, seize them, haul them to the US, and disappear them into a prison. Next decision is the decision, as that quote just suggests, to prosecute a non-US citizen living outside the US on the basis of conduct carried out outside the US. And if we changed that to China or Russia, I think there would, of course, be a great outcry. When it's an ally, somehow that's supposed to not be as much of a problem. Now, Greg, I think, is going to talk much more about the basis of this kind of extraterritorial jurisdiction. Suffice to say that there has to be some link between an exercise of criminal law and the person against whom the criminal law is exercised. Usually, we would think that that link is either on the basis of territory, the act took place in the territory, the crime took place in the territory of the state, but that's not the case here, or on the basis of jurisdiction. The person who committed the crime was a national, but Julian Assange is not a national of the US. Or we might say that there's a basis to do so on the basis of universal jurisdiction, that the crime is so universal that any state could prosecute it. Think genocide, think piracy. But espionage is not a crime like that because states claim that actually it's not a crime under international law, and international lawyers were quick to tell us that when the Snowden leaks came out and we realised how much we'd all been being spied upon. And so we were told, don't worry, espionage isn't a crime under international law. So states with a more ambitious approach to jurisdiction can exercise jurisdiction, claim to exercise this kind of jurisdiction on an extraterritorial basis, either because the crime has effects within its jurisdiction, so that is on the basis of a protective jurisdiction, or on the basis that the victim was from that state, so a passive personality jurisdiction. But suffice to say, it's mainly states that are superpowers, that want to control what happens in other parts of the world, that seek to exercise jurisdiction on this extraterritorial basis. Third choice that I want to focus on then is the decision, or at least the argument so far, that Julian Assange will not be entitled to protection under the First Amendment of the United States relating to free speech. So Assange's defence in the High Court a few weeks ago noted this, that both the US prosecutor from the Eastern District of Virginia, who's been involved in this case, Gordon Kronberg, and indeed the former CIA Director Mike Pompeo, have said that arguably Julian Assange has no rights under the First Amendment because he's not an American citizen. And that follows jurisprudence, or at least some of the jurisprudence on the US, in relation to the Fourth Amendment, so that's protection against unreasonable search, and the Fifth Amendment, that's the protection of due process. So it's an open question whether, despite being subject to US criminal law, non-US citizens have any protections under their Bill of Rights. And again, the New York Times former General Counsel James Goodall said, pretty disturbing that the government would take somebody who's in a country other than the US, namely Assange, and say that he's subject to the Espionage Act of this country, but he doesn't get protection of the other laws that would otherwise protect him. It's the most outrageous goddamn thing I've ever heard. Sometimes the Americans put it frankly. So let's look at the final set of choices made by the UK. The first relates to the decision or the judgment of in the 2021 ruling that Britain's 2003 Extradition Act doesn't bar extradition for political offences, even though the UK-US treaty explicitly does. So this goes back to the question of jurisdiction. As I've said, jurisdiction is usually based on territory. And even when the US claims to govern all of us through its law, it still requires those being prosecuted for a crime to be present within the territory. To be present within the territory, the US can't just abduct people, although I have to say it does sometimes do that in relation to people who are in Mexico or, say, Colombia, who kind of turn up in US courts arrested with drug offences, but it won't do that for someone who's at least on the territory of the UK. So the US has asked the UK to extradite Julian Assange to face charges under the Espionage Act. And extradition is a process that takes place on the basis of treaties between states. The US has extradition treaties with about 2/3 of the countries in the world, including Australia. Most treaties negotiated initially included provisions that didn't allow extradition for political offences or for extrajudicial, extraterritorial jurisdiction. And this treaty, US-UK treaty, has such a provision in relation to political offences, but the Act that kind of gives effect to that treaty removed that provision. So, again, I think an open question as to why a judge would say that that does not exclude extradition as a political offence. Because, as the UN Special Rapporteur on Torture has said, espionage is the classic textbook example of a political offence. Both the British and indeed the Swedish governments should have taken the position that he should not be extradited for a political offence. The UK has also taken the decision to extradite him despite his illness, again on the basis of US diplomatic assurances. We could remember, for instance, a different position being taken by the UK when the choice was to extradite Pinochet, and they found he was in too serious ill health to face prosecution for his crimes in Chile. And finally, the decision to ignore the findings of the UN human rights bodies, and experts, including the UN Working Group on Arbitrary Detention and the UN Special Rapporteur on Torture, who found that years of prolonged confinement without charge is incompatible with the presumption of innocence and amounts to arbitrary confinement, and that the extent of that arbitrary confinement and surveillance amounts to cruel, inhuman and degrading treatment, cumulatively amounting to torture. Now, those findings are not binding under international law, they're advisory, but again, there's a choice to be made by the state as to whether to take notice of these findings. So what does all this amount to? So I'm suggesting that it amounts to a form of what I'm going to say is imperial law. I don't really use that lightly. I think we're in a world in which rival superpowers or empires are veering towards authoritarianism and using political crimes, including espionage, but also terrorism, to limit critique. And the precedent set by this case, then, is that anyone, anywhere, who engages in acts that affect imperial interests or security, or publish information revealing crimes or corruption, can be charged with political offences and extradited to stand trial and face imprisonment or death. And I just note in passing that we tend to see this more clearly when the state isn't an ally. So when China adopted a new national security law for Hong Kong that kind of opened people up to more political offences, Australia suspended our extradition treaty with Hong Kong for fear that people would then be subject to such a law. As my colleague, international lawyer Holly Cullen from Western Australia wrote at the time, this was important because transferring an accused for trial in another country is implicitly an endorsement of the robustness of that country's rule of law. I think we are, ironically then, less protected against the legal system of an ally if we don't want to kind of offend them and make them worry that we don't think they have a full commitment to the rule of law. And here I think Assange has much to teach us. So in a piece called WikiLeaks and Empire, he wrote about the ways in which forms of communication and secrecy are vital to empire. He said the structured attempt at managing an extended cultural and economic system using communications is the hallmark of empire. And it's the records of these communications, never intended to be dissected, and so especially vulnerable to dissection, that form the basis for understanding the nature of the world's sole remaining empire. The response of the US to the release of the WikiLeaks materials betrays a belief that its power resides in a disparity of information, ever more knowledge for the empire, ever less for its subjects. So where to from here? Let me not end on the completely depressing note Not even the most militarily and economically dominant states are able to control greater spaces alone. Despite the relentlessly insular focus of many US scholars when discussing their government's foreign policy or who has human rights, the decision as to how and where US power is used is not simply a matter for the US, but it's also dependent upon numerous military and intelligence alliances. And taking that seriously might allow us to think about how we would shape a form of international law that doesn't facilitate empire. And as non-aligned states have long insisted, the starting point for resisting oppressive forms of imperial law remain quite old-fashioned mechanisms, limiting extraterritorial jurisdiction, potentially through adopting blocking legislation, or at least insisting upon attaching human rights obligations to the exercise of extraterritorial power, protecting against extradition for political offences, supporting the peaceful settlement of disputes, creating increased pressure for disarmament, resisting the creation and maintenance of foreign military bases, establishing nuclear-free zones, resisting the attempt to expand the legal grounds for resorting to military force, and committing to the peaceful use of the world's oceans. They're quite old-fashioned ideas, but let's give them a go. They might just work. Thank you.
Thank you, Anne, for taking us through the many ways in which the law has been flouted and weaponised, and why that's a danger really for all of us, and where we should be heading instead.